Good afternoon, ladies and gentlemen. I better introduce myself. I am Councillor Anne Eves. This is Councillor Lee Farron and Councillor Christian Berg-Green, who will be hearing the case today. Once all the discussions have concluded, the panel will adjourn to the next room to make their decision, and the meeting will then reconvene in the council chamber when a decision has been made, and we'll tell you what that is. So turning to the agenda, to receive apologies for absence. I don't think there are any, no? Okay. Second item, to receive declarations of interest from members in respect of any matter on the agenda. Do you have any? No? Okay, thank you. The procedure the licensing panel will follow in considering the application is set out in the Licensing Act 2003, its attendant regulations, and was agreed by the Licensing Committee on the 2nd of February 2005. The licensing panel, in accordance with Rule 14 of the Licensing Act 2003, Hearings Regulations 2005, may decide to exclude the public from all or part of the hearing where the licensing panel considers that it is in the public interest to do so. So we are looking now at an application to review a premises license. This is item 3 under the Licensing Act 2003. I would like to remind everybody that individual names of the workers involved should not be used in the open hearing, as this hearing is open to the public and is being live streamed. This is to protect the identity of those people. If it is considered necessary for names to be used, advanced warning should be given so that the panel can take an advice and consider whether they need to go into private session for that section of the hearing. So I would like to ask the premises license holder or his substitute or his licensing consultant, Mr. Paul Thornton, to direct. Oh, sorry. First of all, we have introduction and outline of the report by Mr. Bryant, team leader of Licensing District Council.
Chair, thank you. Members, the report in front of the panel this afternoon is to provide information to enable you to determine an application submitted by the Home Office Immigration Enforcement Team to review the premises licence at a premises called Yaprac, which is situated at 25 to 27 Station Road in Burgess Hill. The application, which is attached in full at Appendix 1, was made pursuant to Section 51 of the Licensing Act 2003. And the grounds for the review relate to the licensing objective of the prevention of crime and disorder. The application details a visit to the premises by the South East Immigration Enforcement Team on the 9th of November last year, when during the visit officers encountered three individuals working at the premises who didn't have the right to work there. There is also a representation submitted by Sussex Police in support of the review application. Now, the panel must determine this matter on the evidence presented to it during the hearing and having due regard to the Licensing Act 2003, the Mid-Sussex District Council licensing policy and the Home Office guidance issued under Section 182 of the Licensing Act. Now, the background to the matter is that the premises has been licensed since August 2021. It's a restaurant-type premises and it's licensed for the provision of sale of alcohol and the provision of late-night refreshment for consumption on and off the premises. Currently, and at the time of the instance referred to within the review application, the premises licence holder and designated premises supervisor is a Mr. Muslim Akar. The premises licence is attached for the members' information at Appendix 2. And the licensable activities and timings are set out in the report at sections 7 and 8. There are a number of conditions currently attached to the licence in addition to the mandatory conditions. In particular, the conditions concern the use of CCTV, notifications which should be made if the CCTV doesn't work. Conditions surrounding staff training, when staff should be trained and when refresher training should take place. And also surrounding a refusals record which should be kept at the premises, which should detail all refusals of alcohol. It also details that the DPS must review and sign the record of intervals of no more than 8 weeks. The full list of conditions are detailed in the premises licence, and there are other conditions which relate to operating Challenge 25 age verification and customers not consuming drinks outside the premises. Now, the Home Office Immigration Enforcement applied for a review of the premises licence in connection with a visit they made to the premises on the 9th of November 2024. And as stated, during this visit, they encountered individuals working at the premises who didn't hold the right to work within the UK. Now, their supporting information and bundle of information is attached at Appendix 4, and obviously I don't propose going through that in detail for members who have had it in advance. It should be noted that separately, a referral was made to the Home Office Civil Penalty Compliance Team in relation to illegal working, and a civil penalty notice for £120,000 was issued on the 6th of January 2025. It was due for payment by the 5th of February. No objection to the penalty was received, and it remains outstanding and unpaid. Within the papers, Immigration Enforcement, as I stated, visited the premises just before 8 p.m. on the 9th of November. They found a total of 12 employees on the premises, of which 3 were identified as being illegal workers. The first was identified as an overstayer on an expired visa with no right to work in the UK. The second was an individual who had entered the UK illegally and was found to be working in breach of his work restrictions. And the third was an individual on an expired visa who had no permission to work in the UK. During the visit, Mr. Akar identified himself to the officers as the manager and confirmed that he employed the staff. When questioned about right to work checks on the workers, his reply was recorded by immigration: "I did not check this, no, I didn't have the time to do this." And it was confirmed the 3 workers concerned were paid in cash. During the visit, the Immigration Service also had additional concerns surrounding the compliance of the additional licence conditions of the premises licence, in particular surrounding the CCTV, where Mr. Akar stated to them he didn't know if the images were being recorded and stored for 28 days and was unaware how to download the footage. They noted that the training records were incomplete and there was no evidence of refresher training. And it was stated to them that some new staff had not received initial training and indicated in particular the member of staff serving at the bar had not received any training. And a refusal log was presented, but this had only one entry dated from May 2023. Now, photos of the documents were taken by the immigration officers, and you will find them within the supporting information that they've supplied. So, Immigration Enforcement in the review submits that Yaprak, under the control of Mr. Akar, has been found to employ illegal workers. The licence holder and agent should have been aware of their responsibilities to uphold the licensing objectives, and they're clearly defined as part of the premises licence application. They state that multiple conditions have also been breached, and their view is that remedying the existing situation, for instance, by imposition of additional conditions or a suspension, would be insufficient to act as a deterrent to the licence holder and other premises licence holders from employing illegal workers and facilitating disqualified immigrants to work illegally. They therefore ask that the panel consider the revocation of the licence and contend that their argument and information is pertinent to that contention. During the consultation period, a further representation in support of the application was received from Sussex Police. Their representation is attached to the report at Appendix 5 in full. They state they're concerned to learn that during the inspection, members of staff were working illegally, and some of the workers attempted to flee the venue as officers arrived. They also note that from the accounts provided by the staff, established that members of staff were being paid below the national minimum wage and in cash. They point out about the illegal workers had either entered the UK illegally or overstayed their permitted visa or had bail conditions imposed, which didn't allow them to be in this type of employment. And they state that this highlights that the premises licence holder has failed to manage the staff at the premises either by way of deliberate act or they state gross incompetence. They note on their representation that they visited the premises on the 1st of July 2025. The DPS was not on the premises, and they stated that no member of staff stepped up as being in charge of the operations on that particular day. Premises were open, customers were in the premises. They stated that the staff were unaware of where the manager was. The free front of house staff were asked if they received training or if anyone held a personal licence, and the members of staff present were unable to confirm this. They point out that they believe that the staff on duty had a poor level of understanding of the English language. It proved too difficult to conduct a full licensing check at the time of their visit. And as stated, they support the immigration enforcement in their request for the revocation of the premises licence. It should be noted, and it is noted in the report, that following on from the review application from the immigration, the licensing team from Mid-Sussex Council visited the premises on the 11th of July to conduct an inspection of the records held in connection with the premises licence. In particular, the training logs, the DPS authorisation and the refusal register. During that visit, a number of photographs of the documents were taken, and they're attached at Appendix 6. It was noted when comparing these documents to the photographs of the documents taken by the immigration officers at the time of their visit, in the previous November, there were a number of misleading entries. In particular, the refusal register on the 9th of November showed, which was taken on the 9th of November, had one entry. The one taken, the picture taken by the licensing officer showed an additional entry dated the 10th of June 2024, which is obviously prior to the immigration visit, but was absent from their photo. The DPS authorisation form on the 9th of November had 9 entries, and the ones taken from on the licensing team visit had a number of entries which predate, 2 entries which predated the immigration visit, which were absent from their photograph on the same form. Training records had 3 further entries dated prior to the immigration visit and were absent from their photo. The licensing authority did write to the premises licence holder and DPS regarding concerns surrounding the veracity and accuracy of these documents, and the letters attached at Appendix 7. I haven't had a response from the premises licence holder and DPS at this time, but I would suspect that this is something which Mr Thornton, the representative for the premises licence holder, will probably address when he addresses yourselves. Within the report, the policy context sets out the legislation, sets out the licensing objectives, requires representations under the Licensing Act 2003 to address the 4 licensing objectives, which are the prevention of crime and disorder, promotion of public safety, prevention of a public nuisance and protection of children from harm. Also set out in the report is selected guidance issued under Section 182 of the Licensing Act, which the members would be well aware of, but it's just to highlight certain parts of, relevant parts of the guidance. The guidance states at 11.16 that the Act provides a range of powers for the licensing authority, which it may exercise on determining a review where it considers them appropriate for the promotion of the licensing objectives. And it also goes on to state that the licensing authority may decide that the review doesn't require it to take any further steps appropriate to the promotion of the objectives. And there's nothing to prevent a licensing authority issuing an informal warning to the licence holder and or to recommend improvement within a particular period of time. And it's expected that the licensing authorities will regard such informal warnings as an important mechanism for ensuring that the licensing objectives are effectively promoted, and warnings should be issued in writing to the licence holder. However, where responsible authorities have already issued warnings, the licensing authority should not merely repeat this approach. But similarly, licensing authorities may take into account any civil immigration penalties which a licence holder has been required to pay for employing an illegal worker. And if the licensing authority considers that action under its statutory powers is appropriate, you may take the following steps. Modify the conditions of the premises licence, which includes adding new conditions or any alteration or omission of an existing condition. Exclude a licensable activity from the scope of the licence. remove the designated premises supervisor, for example, because you consider that problems are as a result of poor management, suspend the licence for a period not exceeding 3 months, or revoke the licence. And in deciding which of these powers to invoke, it's expected that the licensing authorities, insofar as possible, seek to establish the cause or causes of the concerns that the representations identify. The remedial action taken should generally be directed at these causes and should always be no more than appropriate and proportionate response to address the causes of concern that instigated the review. Um, 1126 of the statutory guidance does point out that where a licensing authority is conducting a review on the grounds that the premises has been used for criminal purposes, its role is solely to determine what steps should be taken in connection with the premises licence for the promotion of the crime prevention objective. And at 1127, it states there is certain criminal activity that may arise in connection with licensed premises which should be treated particularly seriously. And these are the use of the licensed premises for employing a person who is disqualified from work by reason of their immigration status in the UK. And finally, 11.28 of the statutory guidance, it states that it's envisaged that the licensing authorities, police, Home Office, immigration enforcement, and other law enforcement agencies which are responsible authorities will use the review procedures effectively to deter such activities and crime. Where reviews arise and the licensing authority determines that the crime prevention objective is being undermined through the premises being used to further crimes, it is expected that revocation of the licence, even in the first instance, should be seriously considered. And the panel will be required to give reasons for their decision once you deliberated after hearing from the parties in this matter. I shall just briefly go through the background papers and appendices for the panel. Appendix 1 is the application for the review from the Immigration Service. At Appendix 2, I've attached the full current premises licence. At Appendix 3, for members who aren't familiar with the particular location, there are a set of site photographs of both outside and inside the premises. Appendix 4 are the papers supplied by Immigration to support the application. You have the police representation in full at Appendix 5. You have the photos of the documents from the licensing visit of the 11th of July. And finally, Appendix 7, the letter sent to the premises licence holder regarding that visit. And that's the matter before the panel this afternoon.
Thank you very much, Mr. Bryant. Now I'd like to turn to the premises licence holder, Mr. Akar. Is that your name? Can I just check that? Are you Mr.?
Yes, yes.
Here's Mr.
This is, sorry, good afternoon, Chair. My name is Paul Thornton. I'm a licensing consultant and I'll be representing, this is Mustafa Akar.
Right.
Mr. Muslim Akar, who is the premises licence holder and the DPS, regrettably can't be present here today. His very young daughter has got an urgent GP appointment, and I can elaborate on that later during my address, if that's okay with you.
No problem, yes. Okay, that's great. So what I'm asking you now, you will have an opportunity to make your case obviously a bit later on. I'm asking you now just whether you have any questions to the senior licensing officer.
No, I don't, Chair.
Okay, thank you. And I turn to the Home Office rep. Do you have any questions to Mr. Bryant? Thank you.
No, I don't have any questions for Mr. Bryant. Thank you very much.
Panel members, do you have any questions to the senior licensing officer?
Not from me.
Not at this stage, right, okay. We move now to the Home Office representative, if you would like to make your application. Thank you.
Thank you very much for hearing our case this afternoon. I would like to confirm that all of the committee members have had time to read our submission pack. I can appreciate it is quite lengthy. There is a lot to see in it, but I don't propose to reread the full pack, but I'd like to make a couple of key points adjacent to what it contains before summarising the case. The ability to work illegally is a key driver of illegal migration. It encourages people to break the UK's immigration laws, and it provides the practical means for migrants to remain unlawfully in the United Kingdom. It encourages people to take risks in trying to enter the UK illegally by putting their lives in the hands of unscrupulous people smugglers, which leaves them vulnerable to exploitative employers. Illegal working results in businesses that are not playing by the rules and undercutting legitimate businesses that are. It also negatively impacts on the wages of lawful workers and can be linked to other labour market abuse, such as tax evasion, breach of the national minimum wage, and exploitative working conditions. Working illegally is a criminal offence, and on conviction in England and Wales, an illegal worker may receive a custodial sentence of up to 6 months and an unlimited fine. Employing illegal workers undermines the licensing objectives, specifically the prevention of crime and disorder. Immigration enforcement do not just drive around looking for businesses to target. We're an intelligence-led organisation, and there must be significant concerns for us to action incoming intelligence. We do not routinely refer to seeker licence review, but we do so in selected cases where we have heightened concerns. In this case, we have multiple people who were working illegally over many months. Immigration enforcement received an allegation of illegal workers being employed at these premises, specifically stating that the owner chooses illegal workers as he can pay them less money. As a result of this allegation, an enforcement team visited the restaurant on the 9th of November 2024, where 3 offenders were encountered. As it was noted by Mr. Bryant, there were 12 employees encountered, 3 of which being offenders. I would argue that 25% of your staffing being unlawful is quite a considerable proportion. On arrival, 3 individuals were seen running from the rear of the premise, and all 3 of those attempting to abscond were subsequently arrested as immigration offenders, and they are detailed in the review pack. The first worker was an individual who came to the United Kingdom on a temporary seasonal work visa. That visa expired on the 11th of the 4th, 2023. So by the time immigration officers had encountered her in November of 2024, she had been in the United Kingdom for 17 months longer than she was permitted to be, which means that she was illegally present for the entire duration of her employment at Yaprak. The manager confirmed her employment, stating that she carried out washing in the kitchen and that she receives cash payments for that. The worker claimed to work for around 48 to 54 hours per week, which at UK minimum wage would attract a rate of pay of £586.08 to £659.34, making the £450 she stated she was paid substantially under minimum wage, which is understandably a cause for concern. The second individual had illegally entered the United Kingdom in March of 2022. He made an application with the Home Office, which was refused in December of 2023, and lodged an appeal in January of 2024. When questioned, the individual stated that he worked as a waiter clearing tables. He stated that Mr. Akar offered him the job and would pay him cash in return for his work. He did not provide any documents to the employer to conduct immigration or right-to-work checks prior to commencing work. His bail conditions allowed him to work in jobs that fall under the shortage of occupation list. However, working as a waiter in a restaurant does not fall within this list, and it is the employer's obligation to check that the employment they are offering someone fits that. Therefore, he was found to be working in breach of his work restrictions. The third worker came to the United Kingdom again on a temporary seasonal work visa, and that visa expired in April of 2023. He placed an application with the Home Office in May of 2023. However, as he had already overstayed his visa, he was given immigration bail conditions. Part of these conditions were that he is not permitted to work in the UK. The individual stated that he does cleaning at the restaurant, usually 2 or 3 times a week for 2 or 3 hours a day. He confirmed that he was paid £5 an hour in cash by the manager. By his own admission, and made clear by being encountered doing so, he was working in breach of his immigration bail conditions. When questioned if the employer had conducted any right-to-work checks on him, he replied, "No, I told him I was allowed to work and he didn't ask any more." This is understandably deeply concerning. The manager only taking the word of someone and not undertaking the lawful checks that they are obligated to. The employee stating they were paid £5 an hour is also being substantially underpaid, given that the UK minimum wage is £12.21 an hour. A referral was made to the Civil Penalty Compliance Team in relation to the illegal working, and they did impose a penalty of £120,000 on the 6th of January 2025. The penalty was due for payment on the 5th of February 2025, and as of this review being submitted, the penalty is still outstanding and unpaid, but unchallenged. The manager confirms that he employed the staff on the premise himself, and when questioned if he had done the necessary right to work checks on the workers encountered, he replied, "I did not check this, no, I didn't have the time to do this," showing how utterly blasé he was about what is not only a condition of his licence, but a legal requirement. Based on the findings of the visit in November, it's considered that the licence holders adopted a two-tiered approach to staff, those who have the legal right to work and those who are off the books. As mentioned before about the proposition of any period of suspension or imposing conditions, other than those relevant to CCTV, unfortunately do little to prevent the illegal working that we have evidenced. So we as the Home Office would like you to consider full revocation of the licence. Section 182 guidance at point 1127 outlines that certain criminal activity that may arise in connection with licensed premise, which should also be treated particularly seriously. This includes employing a person who is disqualified from that work by reason of their immigration status in the UK. Point 1128 states that where a review arises from such activity and the licensing authority determines that the crime prevention objective is being undermined through the premise being used to further crimes, it is expected that the revocation of the licence, even in the first instance, should be seriously considered. I do think it is also worth noting at this time the integrity of employers who are retroactively amending records for the sake of claiming compliance. With all of that being said, we do recognise that our role is to bring these concerns to your attention as the local licensing authority. It's your area, and it's you that answer to the electorate and represent the interest of the local people. In line with the guidance, the Home Office Immigration Enforcement is seeking for the subcommittee to consider revoking the premises licence. Unless I can answer any specific questions, I don't propose to take any more of your time, but thank you very much for your consideration.
Thank you very much indeed. Can I turn first to Mr. Bryant to see whether you have any questions to the Home Office representative?
No, thank you.
And to Mr. Thornton or to Mr. Akar, do you have any questions?
None, Chair, thank you.
And members, do you have any questions at this stage? None. Lovely, thank you. So now we turn to the licence holder and his consultant, Mr. Thornton or Mr. Akar, to make your representation.
Good afternoon, Chair, members of the committee and everybody else present. My name is Paul Thornton, and as you just stated, I'm a licensing consultant. I'll be speaking on behalf of the current premises licence holder in DPS, who's Muslim Akar, who's not here this afternoon, and Mustafa Akar, the manager and current owner of the business, who is sitting to my right. Muslim and Mustafa are cousins, and Mustafa does not intend to address you this afternoon, but clearly is here if there are questions that need to be asked and answered. Can I start by saying that nothing I say or propose this afternoon can change the circumstances of why we're here. So we can't turn the clock back, and history is history. I can assure you as a committee that my clients are extremely worried for the future of their business and are absolutely under no illusions as to the severity of the situation they find themselves in. I'd like just to reference the representations from the three responsible authorities very briefly. I don't intend to rerun the immigration offences. The immigration team clearly interviewed Mr. Akar at length during their visit. The offences are not in dispute, and the business owners have been punished in accordance with the relevant legislation. Shortcomings around the Licensing Act as identified by visits by the Immigration Service and your licensing officers are equally plain to see. At this stage, I should address Mr. Bryant's letter at Appendix 7 regarding a number of documents that were blank when the immigration team visited in November, but have been completed and indeed backdated when your licensing team visited in July this year. Mustafa Akar completed those entries. He was aware after the immigration officer's visit that documents that should have been completed and contained dates for training were blank. And as I say, he was aware after the immigration officer's visit. His naivety led him to go back through staff records and enter dates for training and authorisations in a spirit, he tells me, just simply for completeness, because they were blank. He'd been told they should have been filled in, they weren't, and he's gone back and filled them in. I would submit there can be absolutely no suggestion this was done as an intention to deceive, as he'd already been made aware of the shortcomings. And it's a matter of record, and obviously not disputed, that the records were not completed in accordance with the conditions on the premises licence. I would invite you to accept that ultimately it is naivety and a desperation to try and correct a mistake rather than a sinister attempt at deception. And as an aside, if I can add on a personal note, if it was an attempt at deception, it's probably one of the worst attempts that could possibly be imagined. But I move on. Sussex Police submitted a representation from Inspector Butler that references licensing shortcomings, and it cites a licensing visit by them on the 1st of July this year. They state it had to be abandoned because the staff present had such a poor understanding of the English language, and so they were unable, in their words, to establish any breaches of the licence, equally probably unable to establish any compliance with the licence. Mr. Akar, and indeed myself, are surprised at this turn of events because one of the senior members of staff present that day I've previously met some 6 years ago, firstly in the licensed premises in this district, and latterly in a neighbouring authority, and I'm able to hold a perfectly normal conversation with him in English. He is Turkish, but I can have a perfectly reasonable conversation with him. And when this was this representation was served, both Mr. Muslim Akar and Mustafa were very, very surprised. So it rather skews the last part of the police representation, because the last paragraph of Mr. Butler's representation summarises the shortcomings found by immigration and your licensing officers, and concludes that the police inspection also uncovered a total disregard to the licensing conditions, and that the restaurant has failed to uphold multiple licensing objectives. But I would suggest that the last two paragraphs of that representation are completely contradictory. One says they couldn't conduct a licensing visit because of the poor state of the alleged understanding of the English language, and yet the following paragraphs indicates they found multiple breaches but aren't itemised. I'm not in any way trying to diminish the findings from the immigration officers and the council licensing team, but I'm not sure that the Sussex Police licensing actually enhances the level of non-compliance that they seem to think that visit on the 1st of July did. So I would therefore invite you to consider their comments accordingly in the light of my comments. Having said that history can't be changed, I'd now like to give some background to the premises and suggest a way forward for this matter. In January 2023, Muslim and Mustafa Akar acquired the premises and for the next 5 months spent a considerable amount of money redecorating and refurbishing the premises, which opened for business in May of that year. In October 2023, Muslim Akar sold his interest in the business to his cousin, Mustafa. However, he retained his name as the premises licence holder and the DPS for the site. He recognises this as a dereliction of his licensing responsibilities, but he tells me that he needed to rid himself of the business. Indeed, at this time, selling his interest in Yaprak, he also sold his interest in other businesses. And the reason for this is that his daughter, born in June 2022, was admitted, in fact, a week before they took over the Yaprak officially, was admitted to Great Ormond Street Hospital in January 2023, where she stayed as an inpatient for the next 6 months, being treated for a very, very serious condition. Upon discharge in July of 2023, she had 3 appointments a week as an outpatient, clearly taking its toll on Mr. Akar and his wife. And in his own words to me, he said he just completely lost focus and lost his head for the business. So we had a situation in October 2023, which to be fair had been brewing for a little while, where Mustafa is now running the show. And although he has experience of being a manager and an employee, the weight of being in charge of it all is somewhat different. Hence the immigration offences and licensing breaches. He tells me that he just carried on as he had done with where Muslim was in charge. And as I say, I'm not going to rerun the immigration offences because he was interviewed very fairly and extensively by the immigration officers and indeed by your licensing team and gave open and honest answers. Interestingly, it would be fair to say now and then the restaurant has not attracted the attention of police or the licensing authorities for disorder, noise, or any suggestion that sales to under 18s or to children and young people are being made. The restaurant is thriving. It is a clean, well-decorated, double-fronted site in the centre of Burgess Hill, with a 5-star food hygiene rating from your environmental health team. It has good footfall, sorry, Freudian slip, and a regular client base, and currently has 11 employees, including Mr. Akar. Members of the committee, you will all recognise and understand that the hospitality industry is on its knees. I don't need to elaborate the multitude of reasons for this, but the bottom line is that both Muslim and Mustafa Akar recognise the severity of this situation. You've got a difficult decision to make, balancing the advice and guidance from HM Government via the Section 182 guidance, together with clamour from the responsible authorities suggesting the revocation of the premises licence against the inevitable economic consequences for a successful business in one of your town centres. I'll draw the committee's attention to the full wording of Section 182 guidance, which is contained within Mr. Bryant's report and which the representative from HM Immigration has just read out. It says, where reviews arise and licensing authorities determine that the crime prevention objective is being undermined to the premises being used to further crimes, it is expected that revocation of the licence, even in the first instance, should be seriously considered. I'm not sure that the line there says where the premises are being used to further crimes. Does that mean the immigration offences, or does it mean immigration offences and further crimes? I would contend that, yes, the immigration, I'm not diminishing the immigration offences, they are serious. But I would suggest to you that this premises is not being used for further crime. There are other ways short of revocation to deal with this matter. The loss of the ability to sell alcohol that accounts for 30 to 40% of this premises turnover would be catastrophic for the business and would inevitably lead to its closure. That, however, is clearly not a reason to debar you from revoking the licence, but it is a fact of business life. It's my job now, having discussed the history of the site and identifying why we're here, to move forward and suggest a plan that will, in my view, ensure future compliance and ensure that a successful business can continue to operate. Now, I'm not qualified to give professional immigration advice, but I pointed Mr. Acar in the direction of government guidance on the subject, and he now has an understanding of what his responsibilities are. He has introduced his checklist and a binder with copies of all documents for permissions to work for the staff, and tells me that he is on top of all of that, and all of his staff he currently has checked. Now, the next issue is to address the premises licence and the DPS. As we already know, the premises licence holder and the DPS are shown as Muslim Acar. Clearly, that cannot continue. Mr. Muslim Acar has no place in the running of this business at the moment. Now, I might add now that I've been instructed on this matter very, very late on. Days rather than weeks spring to mind. And so if there's a question going through everybody's heads saying, why now? It's because neither Mr. Muslim Acar nor Mustafa took any advice about this until very, very recently. And clearly, with today's proceedings looming large, there was little point in changing things on a licence which 5 o'clock this evening may not even exist. So, what are my proposals? My proposals will be that the premises licence is transferred to a company called Aygan Limited, AYGAN. This company is owned by a business partner of Mustafa. I stated earlier that Muslim Acar has nothing to do with the running of the business, and he's got nothing to do with this new company, and so he will not have any influence whatsoever. Next, Muslim Acar needs to be immediately removed as the DPS, either by a decision that you make here this afternoon, or voluntarily by the business. And I'll come on to the question of the DPS in a minute. Next, Mustafa Acar and one other person in the staff, and I have his name here, but I won't mention that at the moment, but can tell you privately, obtain personal alcohol licences with a view to Mustafa becoming the DPS. The process of obtaining a qualification and being granted a personal licence should take no more than 8 weeks, I would suggest. This process will give both men, both Mr. Acar and the other member of staff, the licensing knowledge, information, and indeed identify the results of non-compliance to them. In short, it will complete their licensing education. In the meantime, until Mustafa becomes DPS, I'm proposing a responsible and very experienced personal alcohol licence holder, personally known to me for a number of years, and who's also known to Mustafa Acar, is made the DPS. Now, this man is not currently the designated premises supervisor of a licensed premises elsewhere, so it's not a question of a DPS of convenience. He will be supervising the business, but I would say he does have a takeaway business, but that's not currently on this district, on a different district. but it has no, it's not a late night takeaway, and it is not currently licensed. So he does not have that responsibility at that premises. I am able to supply this man's details to all necessary responsible authorities today, should they wish to see them. Now, in addition, I've been engaged by Mustafa to provide training for the staff, to check all relevant documentation and to visit the premises initially monthly, but if required on a far more frequent basis, to monitor and do compliance check on the paperwork. And in addition, I will liaise regularly with the incoming new DPS should you accept this proposal. I draw your attention to the fact that when the Immigration Department visited on 9th of November, their investigation concluded with a fine being imposed on the business on the 6th of January 2025. Review papers weren't served to the licensing authority till 6 months later. And bizarrely, during that time, Mustafa Akar has actually run this premises business-wise, run it very successfully. And again, where he's been managing the site and running it, it's not attracted any attention whatsoever from the responsible authorities in relation to disorder, noise, or any suggestion that children and young persons are being sold alcohol. And I say that notwithstanding, and I don't make light of it, but in relation to the perceived offences that the police found on the 1st of July. So despite everything, the premises continues to trade well, with a strong footfall and turnover, and yet it's caused no concerns to the responsible authorities since those initial visits. Members of the committee, I'm going to repeat, I don't underestimate the gravity of your decision this afternoon. Weighing as you have to do the undisputed facts of non-compliance against a decision that in all likelihood will lead to the closure of another town centre business. I would reiterate there's no evidence to suggest that the premises is being used for other criminal activity, and that I submit is a key point from the Licensing Act guidance that I read out when considering revocation. I make the proposals in an effort to move this matter forward and to try and convince you that my clients are acutely aware of the serious situation they're in, and that Mustafa Akar is serious about the need for compliance in the future. I believe the measures outlined are sufficient to give you confidence in them and to ensure that the business can move on. I would therefore urge you to recognise the business as a thriving asset to your district and to give them a chance to prove that they comply with all relevant legislation. Members of the committee, thank you for your time this afternoon.
Thank you very much, Mr. Thornton. Mr. Bryant, any questions to Mr. Thornton?
No, thank you, Chair.
Ms. Riordan, any questions to Mr. Thornton?
Yes, just a little. The point, the 11.28 guidance, the quote there is, the licensing authority determines that the crime prevention objective is being undermined through the premise being used to further crimes. Mr. Thornton, are you stating in further crime you meant additional crime? Because from the wording of the 11.28 guidance, I believe that to mean to further crime, as in to aid the crime that has already been committed. In this case, the crime that has already been committed is illegal working, and therefore crime is being furthered on that premise because those illegal workers are being given the opportunity to work illegally. So are you trying to say that we had said other crimes were happening there? Because I don't believe that to be the case.
Mr. Thornton.
If I understand it correctly, Chair, My point is that I don't believe that the premise has been used for further crimes, notwithstanding that clearly the immigration offences have already been dealt with. I'm not suggesting that the immigration are saying that further crimes are being committed there, but that was my understanding of that point.
Thank you. But your understanding is it's more to promote crime. That's what that wording means.
So the wording on it is used to further crime. So as in, the people that are illegally present or wish to work illegally are being given that opportunity within that business. So crime is being furthered, it's being aided. We're not at all speculating that other crimes are happening there. We're saying that the crime being illegal working, is being furthered within that business. And also, just an aside, as you've mentioned that you said the crime of the illegal working has already been dealt with. I'm assuming you're meaning by way of the civil penalty referral notice that was imposed, because that isn't relevant to this case. The civil penalty being issued proves beyond doubt that the civil penalty compliance team believed there to be illegal workers there. However, the fine that was imposed by that team and for that does not come into play as to whether it's relevant or necessary to take the licence and revoke the licence in this hearing here.
Okay, understood. Do you want to comment on that, Mr. Thornton?
No, Chair.
Thank you. Panel members, any questions? Oh, I'm sorry, one last question, Home Office.
I'm so sorry. You also mentioned that you'd stated the training logs had been filled in retroactively as a want for completion, which I fully understand. I like a nice complete log, that makes perfect sense. However, in interview, Mr. Akar stated, quote, "They've been trained, but not again." And a second quote to that was, when informed that they needed to be trained every 6 months, his response was, quote, "Oh, I didn't know that." So when you've said that he's gone back in and filled in the logs with the training that happened, how is this training supposed to have happened when he stated that they didn't know that they needed to be retrained and stated they've been trained but not again?
Would you like to answer, Mr. Thornton?
I'm trying to understand what the question is, Chair. I think I do. Simply put, my instructions are that he went back and filled in the training logs for completeness because there were gaps, and as I said in my my main address. I would also reiterate, and I did say it as an off-the-cuff comment, that if it was an attempt at deception, it's a pretty poor one, and with the greatest respect to everybody, I'm not sure that it is being dealt with as a matter of deception, because I'm pretty well convinced that if it was, both the licensing team for this council and Sussex Police would probably have initiated a criminal investigation by now, but they haven't. So, but other than that, I can't answer the question any further than that, Chair.
Thank you. Members, would you like to answer any questions?
I'll ask one. Oh,
Yes,
Christian, you
Councillor Farron.
Yes, for Mr. Thornton. Are you able to say or give a reason why the 120k fine hasn't been paid by the date you're supposed to be?
Bearing in mind this is a public hearing, Chair, I'm not sure whether I might be breaking some confidences with my client. I'm looking to the legal representative for some help here. I'm happy to explain in camera, as it were, outside of the meeting, if it would assist, Chair, but I'm not sure that it would be particularly helpful to a number of parties if I gave some information that I am privy to.
you referring to the privilege against self-incrimination or legal privilege?
I think probably a bit of both, sir, because, yeah, I just answer it as succinctly as that.
So perhaps you could liaise with council on that offline. Yes. Okay, we'll do that shortly. Any more panel questions? Councillor Farron.
Yes. Hello, Mr. Thornton. Prac Burgess Hill Limited was obviously the limited company that was, I presumed, owned in partnership with Mr. Mustafa Akar and Mr. Muslin Akar. And this may be again a question for council, is the fine issued to that limited business, or is the fine limited to the person?
I'm looking to the representative from the Immigration Department. My understanding is it's issued to the person, to an individual.
Unfortunately, I wouldn't wish to give a definitive answer on this, as I personally, my team doesn't issue the fines. I'm from an immigration compliance and enforcement team. I simply fill out the paperwork to say, this is what I have witnessed here today. I would like to refer it for the consideration for a fine. The civil penalty compliance team issue the fines. From my belief, I do believe that they can be issued to a business, not necessarily specifically an individual. I don't know which it was in this case. As like I said, unfortunately, I don't issue the fines. I just make the referral for the fine to be issued.
Yeah, sorry, the reason for my asking is if it is fine to the business and you want to close the existing business and open a new one, is that a way of deferring the fine? I'm not sure if you're able to answer or...
I'm not able to answer that, so I'm not sure of the ramifications for that. That's for others with far better minds than me.
Any other questions, members? No. Yeah, okay. Does the Home Office want to say anything further?
I do have a closing statement, if
Okay,
that's
go ahead.
appropriate now. Thank you. The Home Office does not wish to be involved in unnecessarily restricting genuine community services, such as successful pubs, restaurants or shops. However, there are concerns over the way that this business is being run, as discussed. Lack of national minimum wage, multiple licence breaches, the employment of illegal workers. And there does need to be some remedy to that behaviour, and a significant way of ensuring that it will not be repeated. This should also serve a clear message to other businesses who are fully compliant with relevant legislation that satisfactory action has been taken. The relevant statutory guidance offers some suggestions, and your legal advisor will also be able to do so, and you might have your own views and concerns to consider. As described, given that 3 illegal workers have been encountered during the enforcement visit, there is strong evidence of illegal working, which themselves they have agreed the offences are not in dispute. In addition to that, the numerous other breaches of the licence condition just goes to show the complete lack of desire to follow the law as laid out to the licence holder, and unfortunately, naivety just simply isn't an excuse. The Home Office have presented this evidence to inform the Licensing Committee's considerations and to draw to its attention the significant risk of the prevention of crime and disorder objective being undermined. In line with the guidance, the Home Office is seeking for the subcommittee to consider revoking the premise licence. It is requested that the Licensing Committee consider the premise licence and take the action that it considers necessary. Thank you.
Thank you. Senior Licensing Officer, would you like to sum up?
Chair, as I say, the papers set out the details for yourselves. The measures that you can take have been set out in respect of this matter. I would point out at this point that at 2.6 and 10.10 of the 182 statutory guidance, it does make reference to potential conditions which can be added to licences in respect of illegal working. But your legal advisor will be able to advise you more on those particular subsections. The information before yourselves is quite clear. The representations made by Mr. Thornton are quite clear. Obviously, for the panel now to make a decision, bearing in mind all the information you've been provided with.
Thank you very much, Mr. Bryant. Any more questions from the panel?
No, thank you. No.
Okay. In that case, the panel will now retire and deliberate and make a decision and come back in and inform you. Thank you very much. Thank you very much. Thank you so much for waiting all this time. Everybody's here, I think. So I'd like to advise you of our decision. We have noted that you have admitted several breaches. You have admitted employing people who are working illegally, not just one person, but 3. You have admitted an ignorance of how the CCTV operated, which is also an admission of breach of license. You have admitted paying very low wages in cash to people, which suggests the fact that it was in cash suggests that you knew it was illegal to do so. You have admitted retrospective filling in of forms, which was a breach of the licensing conditions, and not training employees regularly. So we feel there are just too many breaches there, and we feel that the causes of all this were to seek financial gain. We feel you knew what you were doing, and therefore our decision is, because of the prevention of crime and disorder objective, to revoke the licence. Thank you very much, and the council will be sending you the formal notification.
Yes.
Okay. I think that's all we need to say, so the meeting stands adjourned, and can you just wait for 2 or 3 seconds while the feed is ended? Thank you.